Going to call the meeting of the Texas Speech Language Pathologists and Audiologists Advisory Board to order, and the time on my computer says 10:02. I wanted to remind everyone to please keep yourself muted, except when you're called on to speak. And then the part that's always hard for me to remember is to announce your name each time you speak. So they'll have that for the record. Especially on Zoom, it's really hard to tell who's talking. So that's really helpful. And I'm going to keep drinking lots of water and hoping that my voice lasts through this meeting. I was traveling this weekend and picked up a little something. So we have new members, and I would ask that you just take a minute to introduce yourself. So let's start with Shauna Jackson.
Hi, Shauna Jackson. I'm an audiologist at the Callier Center at University of Texas, Dallas, and I'm a clinical audiologist, but specialties in hearing aids, tinnitus, all of that stuff. So.
Great. And Judica?
Hi, I'm Judika Mehta. I am a professor at Texas Women's University. I'm a speech language pathologist by training, and my focus is everything speech language pathologies.
All right. Well, welcome to the board, and you'll see we'll put you to work right away today. Angelica, would you call the roll, please?
Yes, ma'am. Chevelle Bryant. Thumbs up, gotcha. Dr. Tammy Camp.
I couldn't find my mute button.
Present. Okay.
Present.
Dr. Kristen Culp.
I'm here.
Elizabeth Sterling.
Here.
Stacy Poteet.
Present.
Yay. Sharice Andrews. Going to join us later. Shauna Jackson.
Present.
Judica Mehta.
Present.
And presiding officer Sherry Sensibrian.
I'm here.
Yeah.
We do have a quorum.
Yes, ma'am.
Yes, thank you. That's great. And we'll let Sharice introduce herself or call on her when she joins us.
Yes, ma'am.
Up next on the agenda, Chris Vanderberg is going to do a review of the government training that some of us have been through, and we have new people, so we need to go through that again. So Chris, you're going to share some information with us, right?
Yes, Madam Chair. My name is Chris Vanderberg. I'm a Assistant General Counsel with the TDLR. I'm go ahead and get my introductory speech ready. As you know, the senior members of this board have been familiar with the open records and open meetings process. So I'll try to strike a balance between not encouraging eyes to glaze over, but at the same time hitting the marks that I believe will be of the most utility to your board as you attempt to steward your profession through this, through its variety of issues. And excuse me, there we go. So good morning, Madam Chair, board members. My name is Chris Vanderberg, and while I'm not a new member of 2DLR, I am new to this role as Assistant General Counsel. And as part of my duties, I've been assigned to assist this board in its stewardship of this profession. This was a set of responsibilities until now performed so ably by Miss Wendy Pello. And so before we complete this transfer from Miss Pello to me, Miss Pello has graciously agreed to present the rule package that you see on the agenda for today. As for me, during this meeting, I will limit my time to a presentation of our division's open records and rulemaking training. This training is mandated by Texas State Legislature due to the inclusion of our two newest advisory board members, Ms. Shauna Jackson and I'm sorry if I mispronounced this, Ms. Chiquita Mehta. Hopefully you can get caught up on that at a future meeting. While I've heard these trainings more than a few times while I represented TDLR's enforcement division at this and other advisory board meetings, this will be my first time presenting it as a member of GC. So I hope you will grant some allowance as things go awry. I will try to keep all left turns to a minimum. I also don't plan to read the entire document word for word, but instead we'll try to emphasize this presentation's most important aspects in the hopes of maximizing its utility as you navigate your vital role as representatives of the speech language pathology profession. That said, if at any point in this presentation you have questions or comments, please feel free to ask right then. I'm happy to pause to answer any questions or concerns at any time as best as I can. So with that, I'm going to share my screen, which is always kind of a crapshoot, but let me go ahead and get to that. Excuse me one moment. Here we are. As you can see, my rules here is a bit more detailed and a bit more confusing, it seems. One moment. So, how's your all's weekend? All right, here we go. So what I'm sharing now is our agenda for this meeting. You'll see that there we go. Let's just move on, shall we? Oh, here we are. I'm sorry. Can you all see this document? The agenda for today's meeting. Is it being shared? Not yet. Angelica, would you mind taking over for me? Thank you. It's good to have professionals in the wings. Oh yeah. Oh, it's just the agenda for the meeting itself. Here, let me see if I can share it.
Chris, this is Wendy Pella, Senior Assistant General Counsel. Do you need me to share the PowerPoint?
The
Run through the
PowerPoint.
slides?
Yeah, that would be great. I was just going to use the document in the agenda, but if you have slides ready, hey, well, yeah, go ahead, please. This was working. Oh, I was going to read the agenda and highlights there. There may be GC slides if that's more appropriate. Okay, thank you. I promised left turns, and there. Yeah, I think I am the spot board materials. So right over here. Okay. Then there we go. All right. Look, we're back on track. Thank you for your patience. So the first section that we're going to be discussing is the Open Meetings Act. The OAG for state of Texas, Ken Paxton, emphasizes that sunlight is the best disinfectant, and to that point, the Open Meetings Act requires that any public open meeting where agency business that affects the licensee class over which the agency has regulatory jurisdiction is going to be available to the public with by providing sufficient notice of these public meetings to the public. We provide this following overview of the requirements and prohibitions of the Open Meeting Acts as they apply to advisory board meetings. The key concept with public meetings is the idea of a quorum. Now, anytime with a 9-member board, if 5 members of that board are discussing official agency business, then that meeting, whatever form it takes, needs public notice in order to place the public on notice that rulemaking might be considered that's going to affect their property interests. And so this quorum doesn't necessarily develop solely within a officially designated meeting like this advisory board meeting today. Instead, it can arise really any time that members of a board engage in verbal or written discussion regarding board business. Meetings can consider board business or takes formal action on board business. If that happens, if a quorum forms and takes that kind of action, the public needs to know about it. And so this quorum situation isn't relegated to a meeting space like this. Instead, it can occur it can be triggered in other situations that may not be so obvious. For example, a conference call between 5 members of the board, video conferencing between 5 members of the board, the internet meetings, hallway discussions, emailing, social media exchanges, text messages, any place where a discussion of the board business where formal action could be taken to affect the licensee class could occur. That's when the public needs to know about it. And if the public doesn't have notice about it, there are consequences for the board members involved in this what they call a walking quorum. Now, walking quorum kind of indicates that the name itself kind of presumes a public space or rather a gathering of live individuals talking about things. This is not the case. These walking quorums can exist via an email chain. They can exist via, let's say, a Twitter feed, where various members of the board interact in a discussion that it was just better described as official board business, something that would need to be on the board's agenda in order to be properly discussed. This can also occur on, say, for example, web message boards where a thread develops about a particular topic. If 5 members of the board weigh in on this topic, the public needs to know about it. And if they don't know about it, then there are actually consequences for, as you can see, civil and criminal penalties to any interested person, including the media, may petition the court to stop actions taking violations of the Open Meetings Act. And any action taken as a result of these walking quorums is voidable. That is, nothing can be done, despite, however the elaborate discussions might have been. It also provides, somewhat frighteningly, for criminal penalties for individual board meetings who knowingly participate in a walking quorum, or knowingly participate in, call, or aid in calling a meeting that is closed to the public. The emphasis here is any meeting that's going to, any discussion that's going to affect a licensee class needs to be officially noticed so that the public can attend and, be aware of what potential action, regulatory action could be taken against them. So the best practices is to avoid even the appearance of violating the Open Meetings Act. So, and I'm going to go through this bullet points individually because I think it's important enough to do so. Board members should not meet in small groups, discuss board business, and then communicate those discussions to other board members. You can see here if 2 people talk and then each person tells one more person, and then one of those persons tells a 5th person, we may have a walking quorum. So it's easy to do, even though you might not be intentionally trying to create this sort of situation. The use of emails, text messages, of distribution lists to advisory board members is also something to be avoided. Emails, tweets, communication to a quorum of board members, even if each message is addressed and sent to each board member individually regarding advisory board meetings, just because a message is designed for review by one single board member, if that message is then communicated by that subsequent board member to another board member, and so on and so on, if we hit the magic number here of 5, we've got a walking quorum. Uses teleconference and video conferencing calls when other board members may join in and create a quorum. If it is not a public meeting coordinated by TDLR with sufficient notice provided to the public, that's a walking quorum and avoidable and subjects the members to civil and criminal penalties. We also share work group discussions or information with other board members who are not on the work group. Work groups are segmented classes of board members who discuss individualized topics like enforcement topics, licensing topics, other aspects of the TDLR's functions that impact this profession. We keep these groups smaller than the number of a quorum, so that they do not hit that threshold that necessitates public notice. These groups can function without the necessity of notifying the public of their functionality, because they are under the quorum level. Nothing that they could do could ever become the agency policy or regulatory action. But once that threshold is reached, once we say maybe combine the 2 results of 2 individual work groups, we probably hit 5, and 5 at that point requires public notice. We can ask a quorum of board members, even on an individual basis, for feedback and comments on advisory board business outside of the public meeting. This is called polling, which is essentially conducting an informal vote on the issue. This is the thing that Open Records Meeting is designed to prevent. Behind the doors deals about things that impact our licensees and their property interests, without allowing them any input as to what those decisions are, what decisions that are made. Now, and again, despite how extensive that list was, it is not exhaustive. It is just a list of examples. Technology is expanding at a fairly exponential rate. Our ability to communicate is also expanding, And whenever 5 members of this board communicate in a pattern that allows them to communicate about an issue that should be on notice to the public but isn't, we are in danger of initiating a walking quorum. And that's the whole thing that this Open Meetings Act is designed to prevent. Now, I talked briefly about notice of public meetings. This is the notice of public meetings is what allows agency business to be conducted with a quorum, but with the notice provided to our with our interested parties, whether that be lobbying groups, whether that be individual practitioners, as long as they know if they have provided the content, timing, and posting location of the notice, if they know what we're talking about and they have a chance to weigh in on this, then that's then we've fulfilled the obligations of the Open Meetings Act. We provide this notice in the form of an agenda. Now, the agenda has to be adhered to. And again, there's some timing requirements, at least 7 days before the start of the meeting. We are the board's discussion is limited to the scope of the items on the agenda. If we can't, the discussions cannot expand beyond the scope of the agenda. As noticed, if something in the public comment portions that may not be agenda is raised, y'all can't talk about it. It can be mentioned at the end of the meeting to be added to the next board's meeting, but it's not. If it's not on the agenda, it's verboten, and it is not something that we can be discussed really in any fashion. Dialogue between public comment and the advisory board members raises a I won't say incredible, but a real risk of violating the Open Records Meeting Act. So, and this doesn't have to be instigated by a member of the public. It can also be instigated by a board member during discussions may propose something that, while tangentially related to an aspect of the agenda, is not really substantially related enough, or is so substantially different that it requires its own agenda item. Those need to be tabled and added to the agenda of the next meeting, because because the public has no notice that this would be discussed, and so has no ability to prepare a response or even to know that this would be discussed. So the best practice to avoid open meetings on the basis of insufficient notice, we really need to specifically identify items for the board agendas and communicate with TDLR staff what y'all want to talk about. We need to limit discussions to the specific agenda items contained in the posting filed with the Secretary of State. That is what the filing with the Secretary of State confers its legitimacy onto the item agendas, and by doing so provide sufficient notice to the public that yes, you have the ability to, you have been notified of this, and if you want to comment, you know where to comment, and you know where to comment to. We can't let the board cannot let specific agenda items wander off into new issues that have not been noticed to the public. We cannot respond to or discuss issues raised in public comment, but which are not on the agenda. Think of the agenda as I guess the text that completely controls what will be discussed, and it is not to be it is not to be wandered away from. Like, this is what we're talking about. Everyone, if it's been properly noticed, everyone knows what we're talking about, and to stray away from what we're talking about does the public a disservice, and it potentially voids any action that we might be taking at a later date. So, in summary, avoid communications that involve quorum of board members without outside of the context of official public meeting. So the magic number is 5. 3 or more, 3 or less, you're probably okay, but you may want to consult with the general counsel's office just to make sure that you're staying between the lines. But frankly, if it's official agency business, the kind that is involved with the stewardship of your industry, I would advise against not discussing this in a format that could potentially lead to a walking quorum. It's just not, frankly, it's just not worth the trouble. Save it for the agenda, for officially noticed agenda. During open meetings, confine discussion to the items specifically posted on the agenda. And by following these practices, you can ensure the continued quality and integrity of the board's recommendations to the Texas Commission, because your role as an advisory board is critical to TDLR's function. But if it's compromised at the advisory board level, it is potentially voidable, and your function is your ability to function is substantially decreased. I realize that's a lot to throw at you, some of it a little bit worrisome. Do you have any questions for me at this point? Hearing none, I'll move on. So this is a separate, but this next discussion is separate from the Open Meetings Act. This is the Open Records Act. In my understanding of this, and I'm not in the Open Records Division, but I've had a fair amount of interaction with them, is that all documents created, collected, assembled, or maintained by the government are open, available to the public, unless a privilege or exception applies to these documents. The board should think that anything that is created as part of official board business, except in case of like attorney-client confidentiality or some other privilege might apply, can and will be part of an open records request and made public in some sort of forum. If you don't want, if it's something that you don't want on the front page of the Texas Tribune, is what I've been told, don't put it in writing. But the writing aspect of it is not just the only, it's not just limited to written business. It's electronic communication, meaning cell phone conversations, text messages, video recordings, voice messages, anything created within the context of TDLR's official business is subject to request and production by our Open Records Division, subject to redaction of confidential information, which the details of which I won't get into, but they do exist and they do apply. Requests for public information are processed through our Open Records Division. We have 10 days to respond, which is a challenging deadline. We can't ask why someone wants this. We can only ask for clarification about the nature of the request. So our TDR's duties is essentially to accede to the request to the extent that our statutory limitations don't apply. So there's information, excuse me, if our Open Records Division thinks that some of the information that's been requested is confidential, like confidential attorney-client communication and work product, information subject to common law privacy, like the identity of victims of certain crimes, or open enforcement investigation prosecution file information, we may request a ruling from the Attorney General's office within 10 business days to see if we can get that information withheld. But the Attorney General's office is a separate entity who has their own, their own analysis that they'll apply to our requests on rulings. And it just because we make this request doesn't mean that it will ultimately succeed. And so to assume that we will not to be able to release information is a dangerous assumption. So my advice as, I guess, GC and counselor is, if you don't want it, if you hesitate to have a something disclosed to the public, if you think it's something that may be too controversial or maybe maybe a kind of a thought in process, I would think carefully about whether it could be disclosed with the proper open records request. This is not to say that you should hide information or try to keep it from being disclosed. You have a duty to the citizens of Texas to make sure that all of the information that we're discussing is available to them to the extent that it's not confidential. But there is a real risk of your ability to serve the public being compromised by excessive documentation. So the takeaway points I would hear is that the public information, the scope of it is large. Paper, electronic records, videotapes, audio tapes, notes, electronic communication, maintained on any device. And that includes potentially a private cell phone with which work information has been stored. Therefore, emails, texts, or the communication stored on personal electronic devices of TDR employees and government offers are considered public information if they relate to TDR business. It's, if possible, keep your work and your business separate. your work and your personal business separate. If you receive a verbal request for a copy of a document of communication that you have access to, you should not provide it to the requester yourself. All requests for information need to be submitted as a written request to our TDLR Open Records Center. Our web address is located on this document below. And if you receive a written request as opposed to a verbal request, please forward that request to the advisory board's teams. They will then follow it up by sending it to our Open Records team as appropriate. And if you were contacted by our Open Records team directly about a public information request, please respond as soon as possible. They function under a timelines that are, well, let's just say, encourage prompt response. This, as you see at the page I'm on, provides additional pretty important information about about the Public Information Act. But I think that the takeaway that I'd like to emphasize is make sure that whatever you document, whatever public records you create, are something that you would be comfortable having anybody read. And also that if you receive an open records request, whether verbal or written, our advisory board coordinators and ultimately our open records division needs to be made aware of these requests as soon as possible. Finally, there's the rulemaking under the Texas Administrative Procedure Act. The Texas legislature grants our agency statutory authority. This statutory authority allows our agencies to create administrative rules to delineate specific procedures that may not exist at the statutory level. As long as these procedures that are created, as long as these procedures that we create in administrative rules adhere to the statutory grant of authority that was prescribed by or mandated by the Texas State Legislature, these administrative rules are I guess, constitutional and allow our agency to continue to function in the discharge of its duties. Now, the process by which these administrative rules are created is a rulemaking procedure, and that is the rulemaking procedure is the primary function of the general counsel. I would say primary function of our general counsel's office, as Ms. Wendy Pella will be demonstrating later on in her rule package presentation. An agency must substantially comply with the rulemaking procedures in the Administrative Practice Act. I won't get into the weeds on we'll get into the specific details of the Administrative Practice Act, but it's it's a complex and time-intensive process, and but at each step, both the the public most likely to be affected by these administrative rules, the internal divisions with perspectives on how these rules are to be drafted, the governor's office, the general counsel's office. Throughout this process, multiple parties are allowed to become part of this drafting process so that each division or group of interested persons has a chance to make their perspective known. And hopefully the ultimate result is one that fulfills the goals of the Texas State Legislature when they granted the statutory authority. Again, again, it's a complicated procedure and I don't want to bog down on that, but the end result of it should be a set of administrative rules that is both conforms to the statutory authority that was granted to us and allows our agency to discharge those obligations mandated by the Texas State Legislature. I'll briefly go over the main steps. The idea for to change or for a new rule, modification of rule, or amendment of a rule can arise from many potential sources like legislation, advisory board members, licensees, other stakeholders, TDR staff, or members of the public. We may use your expertise and generally in part of the work groups that are created from your larger board to help draft language for this proposed rule. We also review the draft by using the expertise of TDLR staff and and view the impact of these potential rules effect on employment, small businesses, rural communities, and state and local governments, as well as assessing the probable economic cost to persons if the proposed rule and ultimately becomes effective. The fiscal impact is required to be included in the preamble of the proposed rule is published. It is then reviewed by the governor's office. If the governor's office is accepting of the rule as drafted, then we present it to you, in this case, the SPA advisory board, for your review to make sure that this is something that the impact and effects are what you need to help guide your profession. We take we take your comments very seriously, and they in turn may require redrafts. But ultimately, we hope to get the proposed rules to a state where the advisory board, where you're, in your expertise, you recognize that these rulemakings will not negatively impact your profession, but instead will help us achieve our mutual goals. And then with that, we take the completed rule set to the Texas Register to allow the public an opportunity for comment. We take those comments, see if that requires additional redraft, and after a 30-day comment period, and a review of the public comments. If a redraft is required, we redraft. But if not, or with the redrafted rules, we take it to a second advisory board meeting. At the second advisory board meeting, which encompasses the public comment period that was instigated by publishing the rules in the Texas Register, we now should have the final set of rules that are assuming that the advisory board can accept the rules in their current written form after taking into account all of those additional suggestions and modifications. Then we present these proposed rules at a commission meeting. The commission being the commission that oversees all of TDLR's regulatory activities. It is their decision that ultimately decides whether the proposed rules can be adopted or not. And if they do adopt those rules as proposed, they're published in the Texas Register again, and that places all licensees or all affected parties on notice that this is now an administrative rule that has the force of law. The effective date of that rule is 20 days after the agency files the adoption notice with the Texas Register. Another way that these rule making sessions can begin is that the APA requires agencies to review all of our rules every 4 years after they adopted to see if they should be repealed, adopted, or amended. Basically, it requires that all of our rules, maybe something changed. Maybe there's a new technology that renders a pre-existing rule moot. Maybe there's a new technology on the horizon that's going to change the way that we do business. We need to be able to look at the rules as they exist and look into the future and see whether changes are going to be made to keep these administrative rules in alignment with the statutory grant that we've been afforded by the Texas legislature. We read the reviews, determine which rules are still necessary and should be adopted, and then the commission may adopt the rules at one of its public meetings. No changes are made to the rules during the reviews process. Any changes that are necessary, they're addressed in future rulemaking. So, and there are additional ways that rulemaking can proceed. I think that this is more of a commission-based focus rather than an advisory board-based focus. I would highly recommend that we read this, but I don't know whether these exact procedures are going to be part of your daily function as a member of this advisory board. So at the risk of glossing over important information, I'll leave that to your to your review. And with that, that completes the mandatory training. I hope I explained the the most salient concepts to you in a relatively clear manner, but I realize I may not. Do any of you have any questions about aspects of this these procedures that I can hopefully delineate further? Well,
Thanks, Chris. I think
oh,
that was pretty clear. I think
oh,
if we have questions, we can certainly, if you think of questions while we're still in our meeting,
okay.
definitely bring it up. But I think everybody understood. Don't meet outside of this setting.
Right.
Sure. Okay. So,
Yeah, and that meeting can take forms, not just like, it doesn't have to be all just like going to lunch. It can be on a Twitter feed, it can be on a web board, comments. I mean, there are a variety of forms. If you have 5 people weighing in on an agenda item, you should contact our general counsel's office.
thank you.
All right. Well, and thank you for your allowance. That was the new board members and I shared a experience there today, and I hope it wasn't too confusing. But again, I'm available to answer any specific questions you might have, and it'll be a pleasure working with you.
Right, thanks. And the board office is always great. The advisory board email, they're great to respond if you have a question or if you have a thought, but you think, oh, I don't want to cause a problem. So they'll get right back to you. So you don't have to be worried about it.
Oh,
The next item.
thank you.
The next item on our agenda is approval of the minutes from our October 31st meeting. We had another one of these Zoom meetings. So I would ask for a motion to approve the minutes.
Elizabeth Sterling, I move to approve the minutes.
Okay, moved by Elizabeth Sterling, and I heard another voice for the second. Who was that?
Val Bryant, I second.
Chevelle Bryant seconded. Thank you. Angelica, would you do a roll call vote, please?
Yes, ma'am. Chevelle Bryant,
Approved, aye.
Dr. Tammy Camp,
Approve.
Dr. Kristen Culp,
Aye.
Elizabeth Sterling,
Approved.
Stacy Poteet, Ms. Poteet, you want to give me a thumbs up if you can hear me that you approve? Great. All right. Shauna Jackson
Approve.
and Judika Mehta.
Approved.
Motion passes.
Oh, I don't think I voted, Angelica.
I'm so sorry. You didn't. My apologies.
Wait a minute.
I was just, I think Officer Sherry sent it.
Too busy checking on everybody else. I vote aye.
Yes, I'm so sorry. Most important one.
That's fine. It took me a second. I went, oh, I think I was just relaxing for a second there. So,
Okay, now we can move on. I apologize again.
all right. Item E on our agenda is public comment. The Speech Language Pathologists and Audiologists Advisory Board received one mailed public comment that was sent to the board last Friday, and one request to give public comment during the meeting. Janita Gilliam wishes to speak this morning. She would have 3 minutes to give her public comment, and the board would not be allowed to ask questions or discuss anything said during the public comment. Angelica, is that person here to present her public comment?
She is. Let me have our staff get her out of the lobby. Sorry, bring her from the lobby. Give me 1 second.
Sure.
Let's see. Don't see her yet. Bear with us. I'm working with staff behind the scenes to get her back. And I did see her earlier, so.
Okay.
It appears she's not in the lobby anymore. If you want to proceed and maybe come back, I can see if staff can try to get her back on.
Okay, that's fine. We'll
Oh,
just
wait,
move
no,
on.
1 second. Looks like she's back.
Maybe.
Hold on.
Okay.
There she is. Okay. Miss Gilliam, do you mind turning on your camera for us so we can see you? Also test your mic real quick before we begin. Dr. Gilliam, can you hear us? Okay. Let's see. All right. Bear with me. All right. I'm not sure if you want to proceed to the next one. Looks like we're having difficulties getting her online. We do have staff in the
Hi there. Let
background
me know
trying.
if you all
Oh,
can hear me.
there you go. Now we can hear you, Miss.
Here. I don't think we
Yes.
can hear you.
Okay, there you go.
Okay.
Miss Carrie, if you want to go ahead and give the little
There we
spiel
go.
about public comment.
Thank you, Dr. Gilliam, for joining us. Thank you for being here. When you begin speaking, we'll have you restate your name and who you represent. You have 3 minutes to speak. Please understand that board members are not allowed to ask any questions or engage in a discussion with you. Do you understand the instructions?
Yes.
You have 3 minutes, and Angelica will keep time. Please start whenever you're ready by introducing yourself and who you represent. Thank you.
Sure. Good morning, everyone. So my name is Dr. Janita Gillum. I represent myself in the private practice with Jabber Talk. I'm a speech language pathologist by trade. Thank you for the opportunity to let me speak with you all. One of my comments was also provided in written format as well, so I won't go through all of that. But I had initial questions regarding the process of the advisory board. Angelica was able to send some information to me so that I could see how that process worked, because there was some miscommunication that was presented in the newsletter, and I wanted to see how those things could be redacted, so that all professionals within the field of speech pathology and or audiology could understand what this board represents, what this looks like, and how they can also be participants, so they know what is taking place at the state level, so that we can make sure that we're advocating as well, for our needs for those who are in the field. My second comment was for everyone on the board to see, at this rate, how are we assisting the SLPs within the school system, as far as maybe with the proposed rules and how that change goes? With Mr. Funderburg, I think, explained a lot, which helped me to learn a lot today. What does that look like as far as the advisory board presenting concerns of, therapy caps and caseloads as an option? Also trying to understand, as the advisory board, are they discussing any information about student loan forgiveness at the state level? And then also looking into the interstate compact for SLPs. Many other states are moving and passing that, and I have not heard anything yet at the state level with Texas. And so I wanted to see if these topics and these concerns are being presented by the board, since I know there are new members that have been, I guess, introduced this month. I just wanted to see if that information could be addressed in your meetings behind closed doors. And then again, how is that information being disseminated to professionals through TISHA and any collaboration with ASHA? And again, just trying to get more information on how you all can maybe, I don't want to use the word advertise, but maybe communicate about these meetings a little bit more to professionals. Because as you can see with your YouTube, there are about 20 viewers, and I know many SLPs are not even aware of this board, what the role is, what the responsibilities are, and again, how we can, get more information. So those are my comments. Those are some of my questions. I'm not sure how I can get answers to those questions, since I know you all are not allowed to comment. But at some point, it would be nice to hear feedback on some of the comments that I just mentioned. Thank you.
Thank you for joining us today, and thank you for your comments. It's always helpful to this board to hear, particularly from the people that the rules affect directly. So thank you. Next on our agenda is the set of staff reports. We have quite a few of those, and it looks like Regina Horton is going to present information from the licensing division. We got some new
Yes.
members.
Good morning, advisory board members. My name is Regina Horton, and I am the team lead for the health professions team. And I will be reviewing or going over the statistics for the speech language pathology and audiology program. Before I begin, I just want to let you know our totals for fiscal year 2023. Some of those numbers are a bit off, and we will be updating them and having those numbers available for you in our next AB meeting, advisory board meeting. I'm sorry. So you should have a copy of the report in front of you. I'm going to start with first quarter fiscal year 2024. The total number of licenses issued for speech language pathology was 213. We renewed a total of 1,762 licenses with a population of 99 for the online renewals. For speech interns, we have a total of 108 licenses that were new issued for the first quarter of fiscal year 2024. We renewed a total of 41 online, and the percent was 100% with 1,071 total population. For speech assistants, the total new licenses that were issued was 180. We renewed 501 licenses online. Percentage was 99%. The total population was 4,937. For audiologists, we processed and issued 17 new licenses. We renewed a total.
I'm sorry, bear with me 1 second. The other reports are not here. Bear with me just 1 second. I apologize. No, I got it. Just give me a second. Okay, sorry about that. Let's try this again.
Okay. So you want me to start over?
No, let me just pull back where you were. I just you did the speech assistants, and here we're down to the audiologist.
Yes.
I'm sorry, everyone.
Okay, so for first quarter fiscal year 2024, the total of new licenses issued for audiology was 17. We renewed 169 licenses with percent of 99 that renewed online, and the total population was 1,619. Let me go back here. And so for audiology interns, the total of new licenses issued was 4. We renewed 2 licenses with 100% that renewed online. The total population was 56. For the audiology assistants, we issued 2 new licenses. 8 licenses were renewed online with a total percent of 100, and the population is 54. So that concludes my report for the statistics for speech language pathology and audiology. Do we have any questions? Thank you.
Right. Thanks, Regina.
You're welcome.
For education and examination, John, as a speech pathologist, I feel terrible when I can't pronounce his name correctly. So, Shieldwater?
Good morning, everybody. My name is John Schuldwachter with the Education Examination Division. I'm very happy to be here today. Thank you all. Yeah, that is a very tough last name. I learned about how to pronounce it correctly maybe in the 5th grade, so don't feel bad. I have before you today the statistics for the jurisprudence examinations. As you can see, the stats are staying fairly consistent with the previous year, 2023. We have our stats up through January of this year. As you can see, there are 10 and 147. And I'm available to answer any questions you may have.
Doesn't look like we have questions about the exam, so thank you for your presentation, and I'll practice Shieldwachter for next time.
I'll be here next time. I'll be ready.
Okay, thanks. Customer Service Division, Patricia Martinez Castellon.
Good morning, advisory board members. I'm Patricia Martinez Castellon with the Customer Service Division. Before you is our statistics for the speech language pathology and audiology program. You'll see that we've had a slight peak in our contacts at the end of our last fiscal year. However, it has been slowly reducing as we come into the new one. Staying pretty consistent, and typically it's answering general inquiries and mainly tracking license status data. Please let me know if you have any questions.
Thanks, Patricia. I know our people keep customer service busy, so thank you.
Thank you.
For enforcement, Shauna Almashuk.
Good morning, committee members. My name is Shauna Almashuk. I am a prosecutor for the Enforcement Division. I believe these presentations are usually conducted by Chris Funderburg, but as you've already learned, he's now with TDLR's General Counsel, and we wish him the best of luck. I'll be presenting the report for you today, and you may notice that we've updated the Enforcement Division's report from our last meeting. So I'll be covering key statistics, case highlights, and case prioritization. At the very top, you have the division's performance measures, which are reported to the legislature. You may notice we have also reorganized the materials so you can compare one fiscal year to another more clearly. You'll notice that the number of complaints opened has decreased significantly between fiscal year 2023 and fiscal year 2024, and the percentage of complaints receiving disciplinary action has decreased as well. The next section is the criminal history review for applicants who may have disqualifying criminal history. And as you can see, none of the speech language pathologist and audiologist applicants were denied licenses based on their criminal history. And these cases are handled by our criminal history prosecutors. The next section details where the Enforcement Division complaints come from, whether they are from consumers or from within the agency. And the top of the next page puts this into a pie graph chart for you. The next section details our caseloads within our Enforcement Division. The orders issued are the end of the road for the disciplinary action, and you can see that in fiscal year 2024, all of the orders that were issued were by agreed order, where the person admitted they made a mistake and paid an applicable fine, which is an improvement from the previous fiscal year when we had more default orders. The penalties and consumer remedies detail how many fines were assessed versus actually collected and shows you the average penalty on these cases. The next section details alleged violations at opening, and these are just the reasons the cases are opened on the front end. And the very last section details the violations which resulted in disciplinary action, and that's the cases we took action on. I've also added 2 case highlights to your packet to provide an example of complaint cases that were resolved by the department staff if you care to review that. And then additionally, today I have some information in your packet about a project that enforcement has been working on at the direction of the Sunset Commission. The Enforcement Division has begun the review of each program's most frequent violations to identify and prioritize those that pose the greatest risk of consumer harm or injury. And the goal is to focus our limited resources on the complaints that have the greatest impact on public health and safety in the most efficient way. There's more detailed information in your packet if you're interested in learning more about this. I'm available to answer any questions that you might have.
Everybody's very quiet. Thank you, Shauna.
Thank you.
And up next for compliance, Erica Rodriguez.
Hi, good morning, board members. My name is Erica Rodriguez. I'm going to be giving the staff report for our compliance division. Some current projects that we are currently working on is we are continuing to work on bill implementation teams for the health and related bills that were passed during the 88th legislative session. We are also continuing to assist other departments within the agency, such as our enforcement department, licensing, education and examination, customer service, with questions, as well as addressing any daily questions and emails that come in from our licensees. We are also assisting our Office of General Counsel with some proposed rule changes. And then also just recently, we have worked with our licensing division to update the fingerprint instructions on the speech language pathologist and audiologist license renewal webpage. This is to include fingerprint instructions with emailed application receipts to streamline our process for submitting fingerprints. Some of the outreach that we have done is just this past weekend, Katie, Bryce, Mary, and I traveled to the TISHA conference. Katie gave a presentation with our presiding officer, Sandy Sensabrian, on ethics course. And then also, we just recently published our Health Monitor newsletter in December of 2023. There are previous editions on our main page of TDLR's webpage. And then I will also be traveling over the next few months to provide presentations to our undergrads and grad students at universities throughout Texas. If anyone does have any outreach opportunities that you would like us to attend or give a presentation at, please contact myself, Erica Rodriguez, and I'll be able to schedule you for that. This does conclude my report. If anyone has any questions, I am here to answer them.
No questions for Erica. A special shout out to Katie for helping to handle the whole fingerprinting issue that came about this summer and caused lots of angst among our licensees. So I think between what she did within the office and then also presenting with me last week, we have lots more people who feel comfortable with what they're supposed to be doing about fingerprinting. We gave a session that was very well received and gave lots of good information about TDLR. Some information that I think is needed. Just listening to the person who made the public comment, people still don't understand the function of TDLR versus voluntary associations like TAA and TSHA. So it was very helpful to have TDLR represented in that session. The last of our staff reports is from the Executive Office, presented by Deputy Executive Director Brandy Myers.
Good morning, Presiding Officer and board members. My name is Brandy Myers. I am the Deputy Executive Director over Administrative Services here at TDLR and wanted to give you some updates on personnel. So the last time you met, Christina Kaiser, who was our Senior Deputy Executive Director, was our Acting Executive Director at the moment, but she has retired. She retired at the end of December, and so we have our former Executive Director, Brian Francis. He's actually back with us, and he is serving as the interim executive director right now. And so we're glad to have him back. And then Steve Bruno, y'all may recognize that name and recognize him. He was our legislative director at the agency, and he is now the deputy executive director over our licensing services. So he's over licensing and customer service and our education and examination divisions of the agency. And while I'm new to my role as Deputy Executive Director, I'm not new to the agency. I have been here for almost 5 years, and prior to serving in this role, I was the Chief Financial Officer for the agency. So I'm happy to be here and happy to serve with you. And if you have any questions, please let me know. As we move on to the next item under the Executive Office update, it's the legislative session and bill implementation update. Since y'all met in October, y'all have had those updates and there's nothing new to report on this agenda item. So that concludes my remarks and I'm happy to answer any questions.
I think we don't have questions, so thank you for your report, Brandy. Up next is item G, and Wendy Pello, who knows our rules very well, is going to give you an update on revisions to our rules.
Good morning. Wendy Pello, Senior Assistant General Counsel. The rules on the agenda today under agenda item G, these are updates that we discussed at our last meeting on October 31st, 2023. There's the specific rule sites are listed on the agenda under item G. We would walk through these rules at our last meeting, so I won't walk through them again unless requested by any advisory board meeting. I won't pull them up again, walk through them section by section, but I can if we've got questions. But I do want to just kind of give everybody a refresher of a highlight of kind of what the changes were. The changes were kind of in I call it four groups of changes, kind of grouped into one rule package. The first was a change that would allow a licensee to provide proof of licensure to a requester through the department's online license search as an additional option, in addition to showing the licensee's current license certificate or license identification card. And this was a change that had come up from the advisory board's licensing work group and had recommended this change. And what initiated is how to address how a licensee may provide proof of licensure to a client, especially in those cases like, when you're providing telehealth services or services outside of an office setting when it may not necessarily be convenient or maybe be burdensome to carry your card in a clinical setting. So that's the first change that was made. The second major kind of category of change was addressing cognition screenings as part of the communication screenings, and having the rules specifically provide that cognitive processes affecting communication function may be screened for under communication screening. And this was a change that had come up from the standard care work group had recommended this change. This is reflecting kind of the current practice of allowing, reviewing language, speech, cognition as part of a communication screening, and allowing providers to include that as part of the communication screening. The third category of changes is kind of ends up with a variety of miscellaneous changes in the rules package, but they're clarifications and cleanup changes that came to the existing rules and updates to statutes and rule citations. And these changes were a result of the department's 4-year rule review. As Chris mentioned earlier in the rulemaking process, we do review our rules for every rule chapter every 4 years. And so these are select changes that came out of that rule review and as they relate to kind of cleanup and clarification changes. And then the fourth kind of group of changes was technical corrections that involved the telehealth rules, specifically the emergency telehealth rules and then the comprehensive telehealth rules that quickly followed. And that was just cleanup and removing remaining in-person supervision references that were inadvertently not removed in those previous rulemaking. So those are kind of like the four groups of changes. Any questions on that before I get into comments? Does anyone need to pull up any rules? You do have the proposed rules in your packet, but I can pull anything out on the screen if you need me to. Not seeing any hands. Okay. We did, at your last meeting, we had, like I said, walk through those rules, and the advisory board had recommended the proposed rules be published in the Texas Register for public comment. We did publish those proposed rules in the Texas Register, and they were published on December 22nd, 2023, and the public comment period closed on January 25th, 2024. And as a result of that public comment period, we received one public comment, and it was from the Texas Academy of Audiology, TAA. In general, the TA supported all the changes to our proposed rules, and they did comment kind of on those four groups of changes about the licensing providing proof of licensure. They agreed with that change. I thought it was kind of reflecting today's industry and profession, reducing administrative burden. They also agreed with the cleanup changes and the clarifications that were results of rule review, and then also removing those in-person supervision references. They did have, they also supported the changes on the changes about the communication screenings in terms of including cognitive processes, and that they agreed with those changes, and again thought that those reflected kind of the holistic communication evaluation, and it was aligned with current practices and the current language. They did point out, and rightfully so, that the screenings are distinct from medical evaluation. These communication screenings are not medical evaluations, so they pointed that out, in their comment, and we agree with that. These are two separate things. They did they suggested maybe including some type of monitoring in terms of monitoring how those screening tools are being used, and maybe in the advertising. That we have a discussion. It's not something that our compliance division does, but that's something definitely we keep an eye out for, is if we receive complaints on those type of issues as well in terms of the communication screening. So we appreciate their support on our comments. We didn't make any proposed changes or any changes to the proposed rules based on that comment. But I do want to open that up, the proposed rules and the comment open for discussion by the advisory board. If you have any questions or comments or thoughts on those. I'm looking for hands. Okay. Well, if there's not any comments on the proposed rules or the comments, or if you all didn't have any additional comments, the staff would be requesting that the advisory board make a recommendation to the commission that the commission adopt the proposed rules as published.
Wendy, do we need a motion for that at this time?
Yes, please.
Okay, then I would accept a motion that we recommend that the advisory board recommends that the commission adopt the rules as proposed.
So moved, Tammy Camp.
And a second.
Seconded, Elizabeth Sterling.
Elizabeth Sterling. Everybody's, and Angelica, would you take a roll call vote, please?
Yes, ma'am. Let me just make sure. Elizabeth, you seconded that motion. Is that correct?
I did, yes.
Sorry, let me just write that down real quick so I can. Okay. Chevelle Bryant.
Aye.
Dr. Tammy Camp.
Approve.
Dr. Kristen Culp.
Aye.
Elizabeth Sterling.
Approved.
Stacy Poteet. Give me a thumbs up.
Thumbs up.
Okay. Shauna Jackson.
Approve.
Judica Maida.
Aye.
I'm not going to forget. Presiding Officer Sheridan Cyprian.
Aye.
Motion passes.
Thank you for doing that.
Thank you.
And item H on the agenda is also for Wendy to help us with. These are our work group assignments. So we have work groups that have been in place for quite a while. And Wendy, before we even start, my first question is, do we just continue the same work groups, or has there developed a need for a different work group? Or is this group fine?
Well, these were the 4 work groups that were put in place for kind of the health professions when they were transferred to the department. But if the advisory board feels a need, there's they want to create a new work group, you all have that flexibility to create a new work group. This would be the time and place to do it in a public meeting under this agenda item. But we do also have this existing, there's 4 standing work groups that are there, or excuse me, there's 5. We have licensing, we have education and examination, we have enforcement, we have standard care, and then you all have the joint rules work group that you also share with the Hearing Instrument Fitters and Dispensers Advisory Board. So those are the 5. With the change in membership on the full advisory board, we've got some advisory boards that need some reappointments to those advisory boards, or to those work groups as well. We've got some missing people, and Angelica is pulling up a list, and I think she's highlighted those folks who are no longer on the advisory board where we would need to reappoint. But you could also, like I said, if you decide you need a new work group for any issue, you could appoint that as well, create that and appoint that as well.
Thank you. And of course, it should have been obvious from what Chris Vanderberg told us earlier, that the number of members on the work group is limited very much so that we can avoid the issue of having quorum. So we have either 3 or 4 members on a work group. So first, let me give a chance to the advisory members. I started to say old advisory members, but that's not very nice. So if you were previously, before today, participating on the advisory board, is there someone who would like to change their assignment? Let's do that first, and then we can plug our new members in.
Elizabeth Sterling, point of clarification, are the highlighted ones
Those are
people
ones that
who
we
are,
need to replace. We need to
okay,
find someone for.
that's what I was thinking. Okay.
Yes, yeah, so those are spots that are open.
Right. Okay.
Yeah. And this was in your packet, or I may have sent it on Friday, but I have it pulled up so you can see it as well.
If no one has a strong desire to move to a different work group, then let's just look at replacing positions. Now that Drs. Maida and Dr. Maida and Dr. Jackson have joined us, we've got a full complement again of practitioners, so I think we can plug in fairly easily.
Okay.
So licensing work group, Dr. Jackson, would you be willing to fill in Kim Ringer's spot?
Yes, that's fine.
Okay, so you see what that one is. It's about licensing requirements. And when we have a work group that needs to look over the rules, as we do every 4 years, but also when something comes up, then that group is heavily involved in that. And then Stacy, since you don't have a work group assignment yet, Stacy Petit, would you fill in as our public member? Thumbs up.
Okay. Thank you, because I can't see her while I'm sharing the screen. Thank you.
Yes, we're good. That and she could text me, so. Okay, and then under education and examination, we lost our entire work group, so we need to try again here. Elizabeth, I see your hand up.
I was gonna say I wouldn't mind moving from the joint rules work group to the education and examination work group.
Okay.
Okay.
So then, Angelica, that would mean that she would be replacing Manny Bodner.
Let me go down to the joint rules and okay. Let me highlight right here so I know
that one, and we'll do a switch.
We'll come back. Yeah, we'll come back to that one. All right, let's finish education. So
okay, so our newest SLP on the board, Judica Maida. Dr. Maida, would you join the education and examination work group?
Certainly, yes.
Okay.
Great.
And then Dr. Jackson, could you take this second assignment for education and examination?
Yes, that's fine.
Great. Y'all are awesome.
Makes it life easy.
All right, and then we have one more. Care is good. Everyone's okay with staying on that one?
Everyone seemed okay with keeping that role, so okay.
Yes, I'm good.
So joint rules is a little different. It is specifically audiology because it's joint rules with the fitters and dispensers. So in that case, Dr. Jackson, you get to be Kim Ringer again, okay?
Or do you want to try Sharice Andrews? She's also an
Oh,
audiologist.
Sharice, did she join? I didn't want to assign her, but
that's up to you. If you you're the
that'd
presiding
be okay.
officer.
And we could not have Dr. Jackson have to take on full assignments. That would be great.
Okay. Okay. And then maybe Stacy Poteet for this one, if she's okay with it.
I think that would be fine. Yes.
Okay.
And at some point, I know we will have to look at replacing Dr. Camp on the enforcement group.
Yes.
She's not staying on this board for life. So we'll have to do that as soon as we know for sure when that change would happen.
Okay.
Okay.
And I'll send this out to everyone so they have an updated list.
Thank you.
Great. That's just what I was going to say. I knew that you would send the list out. So thank you for that. Item I on our agenda is anything about recommendations for agenda items for the next board meeting. We did hear our public comment person. mention some concerns that are out there, not all of which I feel like licensure board can address, but Dr. Gillum at least mentioned these 4 things that I wrote down and maybe something else that I missed.
Okay.
Loan forgiveness for people employed in public schools, caseload caps, the interstate compact, and just more marketing of what the board does to the public. Certainly it would be great to have more people joining our YouTube channel. I know it can't always be at a convenient time, considering that this licensure board affects practitioners who tend to have clinic or class or something that they are supposed to be doing at almost any time that we would schedule. So, but certainly they can also watch the recordings. So I think if anybody has ideas about those topics, that those could be good to discuss, and at least to clarify whether those are issues that this licensing board can even address. Other topics.
This is Tammy Camp. Certainly a meeting at the beginning of the day would help those of us who are in practice, because unfortunately when a meeting is scheduled at 10, I have to just, it's just difficult because it's right in the middle of when we would be seeing patients. And so you have a difficult time scheduling patients up until that point, and then you lose 2 hours. And so it would be nice if it started at 7 or 8 in the morning, so that we could, and that's just, maybe that's just my own personal opinion, but that way at least that gives you the time to make up that time maybe during lunch to get people seen.
Okay.
This Elizabeth Sterling. I was thinking the same thing, that an 8 to 10 meeting would be great, because you pretty much have, I pretty much have to take the whole day off to attend, because I really can't drive into Austin and do much before 10 o'clock. And then the afternoon, the kids leave, an hour and a half after the meeting is finished. And so if it were in the morning, then you still have the whole afternoon to be able to do other things and see staff and see students. And so that's just something that the board could consider maybe.
Okay.
Wendy, I see your hand.
Thank you. Wendy Pello, Senior Assistant General Counsel. Tied for recommendations for the next agenda item I, and also with H, possible assignment task. Now that we have work groups, staff has some assignments that will be working with work groups out, so that you may be coming up with agenda items in the future from results of work groups that project staff would like to talk to the work groups about.
Oh, that makes sense. So thank you for that. Dr. Jackson, your hand is up.
Yeah, and addressing her concern regarding the compact, can we get maybe agenda item with some information about if that is a requirement for a legislative passage in order to work on that, or if it is something that just needs to be addressed by the board. If we can get some feedback from the legal side.
Wendy Pello, Senior Assistant General Counsel. Yeah, if the advisory board wants to put an item on the agenda, we'll make sure any necessary documentation or information is provided, so you can have that discussion at that time of the next meeting.
Yeah, Chevelle Bryant, I would like to see that added as an agenda item for next meeting.
And I'm sorry, what is the specific nature of the item that you're looking for? But so I can get it clear.
So we've, in the last 2 legislative sessions, there's been an interstate compact presented for speech language pathology and audiology, and it failed both times. And I think that's what our practitioners are asking to hear more about. So at the next meeting, when it's on our agenda, we can discuss it. We will need some legal input about the role of the licensure board when something's being presented in the legislature. So I have no doubt that General Counsel will give us lots of information about that.
Right.
So
We can provide that to you at the next agenda item. Yeah, the next meeting when it's on the agenda for us to discuss.
So any other topics that we should list on the agenda at this time, given that we may have some added just because they come out of work groups, of course, but anything else? Okay, so we're not going to try to pick a date and time for our next meeting at this time. We hear from Mong Halligan. She can let us know when we need to meet, and then we can talk about it at that time. So that finishes this meeting, and I believe we are ready to adjourn at 11:22.